Thanks, Kathy. And although we're just about midway through the month, let me say Happy New Year because this is the first time I've been here since the new year. So here we are, ready for more business in 2025, and we have an agenda here for you today. I'm actually going to start things off with the presentation about a recent decision from our Second Circuit Court of Appeals for the first 5 or 10 minutes here. And then we have two familiar faces from the webinar. We have Nick Jacobson, who is here regularly with litigation updates, and he's going to talk about an issue that's been in the courts, which is what constitutes an adverse action when we're talking about employment discrimination. Then Adam's going to give us a real nuts and bolts, very practical presentation about paid family leave, retaliation claims, what those look like, what the procedure looks like, because we are seeing an uptick of those. So go right ahead to the next one. That heading slide, though, really did give the bottom line here, which is it has to do with handbook policies regarding reproductive rights or discrimination against employees for exercising their reproductive decision-making rights. But let's go back to the beginning here. I'm going to give you a little context to get to the bottom line here. So there's a law in New York State it's the New York Labor Law 203E that says that employers cannot discriminate against employees based on their reproductive health decisions. So that, of course, includes abortion, most notably, but lots of other things, contraception, and any other number of things in that area. It's a law now, it's a good 5 years old at this point, but it really distinctly lays out that you cannot discriminate or retaliate against an employee because of their reproductive health decision-making or their dependents' reproductive health decision-making. You also can't access employees' personal information regarding those decisions. And if an employee, felt that their rights were being violated under this law and made a complaint, either internally or externally, they would be protected from retaliation for exercising those rights. A familiar concept that we see in pretty much all anti-discrimination, anti-employment discrimination laws. So that's the law from 2019. And there was some litigation on this law right away. Next slide, please. Oh, let me just, this is actually really important. One of the provisions of the law is that an employer must include a notice of the, quote, rights and remedies under the law in an employee handbook, if you have a handbook. So back in 2019, when this law passed, we here at Bond were busy assisting clients writing a policy regarding discrimination against employees based on reproductive rights. Then, next slide, there was litigation. And the plaintiff in the case back in 2022 was a Christian pregnancy center. And they challenged the law on a number of grounds. But for our purposes here, what's important is they challenged it on the basis of their First Amendment free speech rights. And what they said was, by making us put in our handbook these statements that employees are protected based on their religious, based on their reproductive decision making, they're getting protections based on positions that we don't agree with as an organization, forcing us to say things that we don't want to say. And if the government forces you to say something that you don't want to say, that's essentially, potentially a violation of the free speech clause. So, because the free speech clause both protects your right to say things or to not say things. So what happened was pretty significant here, which is the court right here in Syracuse, actually, it was a Northern District of New York decision out of our backyard, said that, you're right. That provision forcing you to put this in your handbook is a violation of your free speech rights. We are going to permanently enjoin the state from enforcing that notice provision. No longer need to have, as an employer, you no longer needed to have a reproductive rights discrimination policy in your handbook. Now, many wanted to and continued to keep such policy in their handbook, but others took it out. Some just pared it down. Instead of having a whole section about the law and what the rights are and what the remedies are, added reproductive rights decision-making into just the general policy against discrimination. That's actually what I see most commonly these days. But anyway, since 2022, this law, that provision of the law has been permanently enjoined. It's like it doesn't exist. It's like it's been deleted from the law. But that wasn't the end of it. That's just the Northern District, meaning that's a district court. That's the lowest level of federal courts. From there, you also have a circuit court and, of course, the U.S. Supreme Court. So next slide, Kathy. Meanwhile, that law, the Compass Care case, wasn't the only case. There were a number of different organizations simultaneously bringing legal action against the state based on this law. So a separate case, the Slattery case, was happening around the same time. This was also another similar crisis pregnancy center, and they said kind of a different argument they focused on, which is First Amendment freedom of association. The idea is who you associate with is sort of a form of speech, right? And what they were saying is the law, by telling us we can't discriminate against people based on their reproductive decision making, you're forcing us to have employees who support abortion rights, and that would be contrary to the whole organization's mission. They wanted to be able to disassociate themselves from employees who seek abortions, and this law basically said you couldn't do that. So the state moved to dismiss this case, of course, and the lower court agreed. The district court level agreed with the state and said, no, you don't have a claim here. This law's fine. It got appealed up to the Second Circuit Court, and this decision came out in 2023 and said, lower court, you didn't do this right. You applied the wrong test. You need to take another look at this. Revived the case, said, you know what, this plaintiff actually does have a plausible claim. Didn't say you won, didn't say that this law is unconstitutional, but said this needs to go back down to the district court for a second look. There might actually be something here. So, and I just put the quote here, although I missed the end quote here on the last bullet. I'm just realizing, sorry about that. An employer may have a claim if the law forces them to employ individuals who act or have acted against the very mission of the organization. So it really opened things back up for consideration by the courts. But the story doesn't end there, of course. So we're going to go on to the next slide, which brings us to today. So the Slattery case sent it back to the lower court, and then they're doing their thing in that case. That brings us back to the Compass Care case that I started with. Compass Care case got appealed to the Second Circuit. And in the interim, the way these things work, litigation moves very slowly. The Slattery case had been decided. And so what the Second Circuit says, based on this Slattery case, which employed a new test that had to be applied, they said, you know, Compass Care also had a similar freedom of association claim, sent it back down to the lower court. So that's going to be pending. But the really big thing, and this is the bottom line that I've been leading up to here since the beginning, it vacated, meaning it got rid of the permanent injunction on a handbook provision. So as of now, this labor law that requires employers to have a policy regarding discrimination against employees based on reproductive rights, decision-making, you must now have that policy. So that's really the action item here. That's why I thought this was worth talking about today. If you have a handbook in the first place, and most employers do, especially if you're taking the time to come to this webinar, most employers do have handbooks. You will need to go back in as of January 2nd. So this is very new, just a couple weeks ago. You will have to go back in and take a look. And if you do not have a separate policy on, discrimination based on reproductive rights decision-making, you'll likely want to go back and add that back in. Like I said, a lot of employers just have reproductive rights decision-making, by the way, which is a mouthful. I keep saying it. They have that in their, just in their general discrimination policy. But technically what the law says is you need to notify employer of their rights and remedies. That's very specific. It's not just their rights, but also remedies. What can they do if their rights are being violated? There's some that would interpret that to mean you really want a separate policy. Some might say that just listing it in your handbook is enough in the general discrimination policy, but something to just take a look at. As at a very, very minimum, you want to make sure if you don't have a separate policy about it, you at least list that type of discrimination in your just general discrimination policy. So something to take a look at. There's always something new. Many of you are probably like throwing up your hands like, I just updated my handbook in December. Come on, January 2nd, really? I know a lot of our clients were very busy in the end of the year updating handbooks, but yes, a new decision January 2nd. And, so just keep that in mind. And that's all I got on that topic. If you have any questions, throw them in the chat. I'll take a look at it as I can here between now and the end of the webinar. But that's all I got there. So I'm going to turn it over at this point to our next presenter, who is Nick Jacobson, who I mentioned at the beginning. Nick's a member in our Labor and Employment Department and splits his time between Rochester and Syracuse. And so he's going to talk to us about some litigation. Thanks, Nick, for being here again.
Thanks, Kristen. Next slide, please, Kathy. So you might recall last year I presented on a federal case, Muldrow versus the city of St. Louis, where the standard for what constituted an adverse action with respect to transfers was changed by the Supreme Court. At this point, it looks like that change might be extended beyond the transfer context. And also, I wanted to take a look at where we stand under New York state law with the standard for what constitutes an adverse action after it was amended in 2019. So prior to 2019, the standard for what constituted an adverse action was essentially the same under New York state law as it was under federal law. For those of you in New York City, there was the New York City human rights law, though, that did apply a different lower standard. In general, terminations, demotions, and unpaid suspensions constituted adverse actions because they were things that affected, the salary and benefits of employees. Other things that affected the terms and conditions of an employee's work, like transfer, denial of training, or unfavorable assignments, could constitute adverse actions if they were significant enough. So, for example, a transfer could constitute an adverse action if it amounted to a significant change in the employee's terms and conditions of employment and created a material disadvantage. A denial of training could be an adverse action where it resulted in material harm by constituting a significant disadvantage with respect to opportunities for professional growth and career advancement. So a transfer to essentially an equivalent position, or at least a similar position, likely would not be an adverse action. The denial of a training opportunity that didn't make an employee ineligible for promotion or something like that likely would not in and of itself constitute an adverse action. Since then, like I said, the New York State human rights law was amended, and we've also seen some changes in the standard under federal law. Next slide, please. So just a refresher for those of you that, or for those of you that may not have seen the presentation on the Muldrow case. So that was a case decided in April of last year. It involved a police officer who was transferred from a position as an investigator to a position as a uniformed officer. She didn't have any loss of pay or change in benefits as a result of that transfer, but she did lose a take-home vehicle. She no longer worked criminal investigations, and she had to work in a regular schedule that included working on weekends. Both the District Court and the Eighth Circuit Court of Appeals applied the material harm test and found that those changes weren't significant enough to constitute an adverse action under Title VII and dismissed the claim. The Supreme Court took a look and decided that the test that the courts had applied and that all courts in the United States at the federal level were applying other than the DC Circuit was wrong. The Supreme Court looked at the law and they said nothing in Title VII requires employees to show significant changes to their employment to challenge a transfer as being discriminatory. Instead, the Supreme Court applied a new standard saying that the transferee must show only some harm to an identifiable term or condition of employment. Here, the court found that the employee was able to do that in several ways, by not having the car, by not working on the high-profile type of investigation she worked for previously, and also because she had an irregular schedule that included weekend work. In particular, that's significant because previously an unfavorable shift assignment, for example, being assigned the night shift, wasn't a significant enough change to the terms and conditions of employment to make a transfer actionable under most courts' rulings. Next slide, please. So while the Muldrow case concerned a transfer, its reasoning could have been applied to all Title VII discrimination cases, right? It wasn't specific to transfers. It was the court reading Title VII generally and saying that there was no requirement that an employee show a significant harm to have an adverse action. Here in New York, courts have generally interpreted Muldrow over the last year to apply outside of the transfer context. In the McCarthy case, the Eastern District of New York in August issued a decision stating that the new reduced standard likely does apply outside the involuntary transfer context. In another case, Anderson v. Amazon, Inc., they applied the Muldrow decision to an action challenging the imposition of a performance improvement plan and allegations that the employee's role had been diminished, that they had been given less responsibility than other employees. And the court in that case found, because Muldrow applied, that those allegations were sufficient to state an adverse action. I will point out courts in other states have disagreed with this. For instance, in the Middle District of Pennsylvania, at least one court issued a decision finding that Muldrow was limited specifically just to transfer cases. On balance, though, I think most courts are applying Muldrow beyond just the transfer context. And certainly for those of us here in New York, we have to expect that courts are going to apply Muldrow to other cases like performance improvement plan cases and things of that nature. Next slide, please. So in addition to the changes under Title VII for federal law, like I mentioned earlier, the New York State human rights law, as we all know, was amended in 2019. Now, I'm sure most people on this call recall the change to the hostile work environment standard, that for harassment to be actionable, it no longer, under New York State law, has to be severe or pervasive. Instead, for harassment or alleged harassment to be unactionable, the employer has to show it's nothing more than a petty slight or a trivial inconvenience. Where the amendment was a little less clear was its effect on discrimination cases that weren't hostile work environment harassment cases, but rather challenged more discrete actions as adverse actions, like the denial of training, transfers, things of that nature. So the 2019 amendment provided that the New York human rights law was to be construed liberally for the accomplishment of the remedial purpose thereof, regardless of whether federal civil rights laws, including those laws with provisions worded comparably to the provisions of this article, have been so construed. Not exactly a vision of clarity as to what the legislature meant there, but it was similar to the language in the New York City human rights law. Next slide, please. So now, sitting here in 2025, you'd likely expect that we'd have the definitive interpretation as to how the 2019 amendments were intended to affect the adverse action standard under state law, but we really don't have a definitive answer at this point. Last year, the Second Circuit issued a decision noting that New York courts have not yet produced any substantive analysis of how this amendment changes the standards of liability under the New York State human rights law, but that some courts in the circuit have interpreted the amendment as rendering the standard for claims closer to the standard of the New York City human rights law. Again, that decision, not definitive on its own, and doesn't even expressly state whether the standard should be identical to that employed under the New York City human rights law. Next slide, please. So where that leaves us is an area of uncertainty. Under the New York State human rights law, a lot of courts have been applying that reduced standard under the New York City human rights law that holds that employees can bring a discrimination case wherever they have been treated less well on the basis of a protected characteristic. That, coupled with the changes under federal law, makes it much more difficult to resolve employment litigation cases on motions to dismiss and motions for summary judgment. The reason being, for example, in a transfer case, the employer might, or the employee might say, I was transferred unfairly, and employees, outside my protected class were treated favorably and that they weren't transferred. The employer might have done it for perfectly legitimate reasons, but it would be possibly easier on a motion to say this change, this transfer wasn't a significant change in their job duties, there's no material harm, and it's not actionable in the first instance. That argument is now a lot more difficult with these changes in the law. Also, employees can bring actions based on smaller changes in the terms and conditions of their employment than they likely could before. For instance, challenging shift assignments, unfavorable tasks, the denial of training and educational opportunities, and even temporary transfers, which generally weren't actionable before. So it's possible that human resources might really want to consider whether there's additional oversight needed, where supervisors had more leeway to make these decisions on their own without consulting HR, or whether additional training is warranted, since there's a greater possibility of exposure to litigation in conjunction with those types of changes. And with that, I'll pass it on to Adam. Thank you so much, Kathy.
All right, yeah, thanks, Nick. And you already took care of it for me, but yeah, let's pass it over to Adam, who's going to talk about paid family leave, retaliation claims. Those who have been listening to the webinar for a long time are well familiar with Adam as the former host here. But Adam, thanks for coming back and giving us an overview of these claims that I think you'll agree we're seeing more of.
Thank you, Kristen, and thank you to everyone for being with us all these years later on Tuesday afternoon. I'm going to talk to you today about paid family leave retaliation claims. Now, there are a number of ways that employees can bring discrimination or retaliation claims against their employers, the most familiar of which are the Division of Human Rights, the Equal Employment Opportunity Commission, in court, or sometimes even retaliation claims related to workers' compensation benefits. However, starting in 2018, when the paid family leave law went into effect in New York, we started to see retaliation claims related to paid family leave start trickling in. As the years have gone on, we're now seeing a steady stream of these claims. So I thought it would be helpful to walk through generally what the law is, what you can do, what's prohibited, and then the process for hearing these claims or adjudicating these claims, which is very different than the other processes that you might be familiar with. So let's start, next slide, please. Let's start with a just very general background on paid family leave and how it relates to these claims. So as all of you know, in 2018, New York State paid family leave law went into effect. It provides employees with up to 12 weeks of job protected and paid time off as compared with FMLA leave to do certain enumerated activities, including bonding with a child, caring for a family member with a serious health condition, assisting loved ones when a family member is assisting loved ones when a family member is deployed abroad on active military service. So that's generally what the law does. Next slide, please. Now, for an employee to take this leave, they have to provide 30 days advance notice to their employer if the leave is foreseeable. And I have that underlined because I have a number of clients who have addressed and dealt with this issue specifically. If an employee cannot reasonably anticipate the leave within 30 days, so let's say there's a doctor's appointment that springs up that they need to attend with a family member, they can take that day as a paid family leave day so long as they follow your normal procedures for calling in. So although the law requires this 30-day advance notice, in practical application, it does not. The general procedure is that the employee fills out the request forms, which are submitted to the employer's insurance carrier, and then the carrier is going to pay or deny the claim. Next slide, please. There are certain protections that the paid family leave law provides to employees, including number one, job protection, which means that employees are entitled to return to the same job or a comparable one after their return from PFL. So if you have a break in service, so let's say somebody goes out to bond with a child for 12 weeks, when they come back, they have their job protected, and you have to reinstate them to the same or a comparable position. Comparable under New York law includes a job with comparable benefits, pay, or other terms and conditions of employment. Number two, you have to provide continued health insurance to the employee while they are out on paid family leave. Next slide. The third and most important protection for our discussion today is that you cannot discriminate or retaliate against one of your employees for taking paid family leave. The state provides the following examples of conduct that can constitute retaliation. So if you don't return the employee to the same or a comparable position, if you terminate the employee, if you reduce their pay or benefits, or if you discipline the employee in any way because they took PFL. Importantly, and I think this is overlooked, the remedies for retaliating or discriminating against an employee for taking PFL include reinstatement, back pay, attorney's fees, and penalties. So the remedies can be very, very significant. If you fire somebody, for example, while they're out on paid family leave, immediately after they come back following paid family leave, and it's ultimately determined that you did so because the employee used paid family leave, you could be on the hook for a serious amount of money. Next slide, please. Okay, so this is more the substance of what I wanted to cover today. It's how do these retaliation claims proceed, and what can you expect as an employer? So first of all, bringing a retaliation claim under the paid family leave law is a multi-step process. So for those of you who are familiar with the division process, there's a form that an employee fills out and submits to the New York State Division of Human Rights. And then that triggers the state division process, which, as many of you know, can take years and years. This process is not like that at all. It's a very quick and streamlined process. So first, an employee who's terminated has to submit a formal request for reinstatement. And I've included a picture of the form. It's a very standard form. The employer then has 30 days to respond to this request. Next slide, please. Let's say the employer decides not to reinstate the employee or their response is not satisfactory to the employee. Then the employee can file a formal complaint. Importantly, paid family leave retaliation claims are administered by the New York State Workers' Compensation Board. And if you're wondering why the Workers' Compensation Board handles paid family leave, your guess is as good as mine, but that's just how the state set up the system. So the employee then files a formal complaint. So first they have to do their request for reinstatement. The employer gets a chance to respond. If the employee is not satisfied, the employee files this form, this complaint form, and serves it on the board. Next slide, please. The board will then notify the employer of the complaint, and then the employer gets 30 days to respond. In the cases that I have handled for employer clients, what we typically do here is we draft a position statement, similar to what you'd write to the EEOC or to the division, explaining why you believe that there is no retaliation claim or providing your legitimate non-retaliatory reasons for doing what you did. So after you submit, next slide, please. After you as the employer, excuse me, submit your answer, the Workers' Compensation Board schedules a hearing. So this all occurs pretty quickly. Let's say employee gets terminated right after they come back from paid family leave. They send you a request for reinstatement. You respond within 30 days and say no. They then file their formal complaint. The board sends out a notice to the employer serves an answer, and a hearing is scheduled within 45 days of the notice to the employer. So this moves very quickly. An initial hearing is then set, and you will have a virtual hearing with an administrative law judge from the Workers' Compensation Board, during which you'll set a date for your hearing. So it's important to note how these hearings are structured. It's different than court, and it's different than the division. You have one administrative law judge who handles all of these claims, paid family leave, retaliation claims. She schedules a virtual hearing in 3-hour blocks. So you may get a 3-hour block to hear testimony, submit evidence, and that may be enough to cover the whole claim, but it may not be. And what happens in that case is that the administrative law judge will then schedule another 3-hour hearing date, but sometimes that's not for months. So you might have your first 3-hour hearing date in January, your next 3-hour hearing date in May, and your next three-hour hearing date in September. It just depends on the calendar. So while these cases proceed much quicker, there's a lot of hurry up and wait. So you'll present your evidence, then you'll wait. Then you'll present your evidence, and then you'll wait. But the important thing here is you have to treat this as though it is a regular trial, because the remedies can be so substantial. It's a shortened process. There's very little oversight other than the administrative law judge making decisions that she feels are appropriate. But it is a trial. Next slide, please. You have to make sure that you have your defenses ready and available to you, the same as you would in any other employment discrimination or retaliation trial. So your defenses could be that the employee is not eligible for paid family leave or was not eligible for paid family leave, or that your employment decisions were made for legitimate, non-discriminatory, and non-retaliatory reasons. After the proof is concluded, you as the employer will be permitted to submit a post-hearing brief if you want, and then the judge will schedule another hearing date during which she reads her decision. So there's no jury, there's no deliberation process other than this administrative law judge reads the decision on the record, and that's the end of it. If you are unsatisfied with the judge's decision, then you can appeal to the Appellate Division, 3rd Department, which is located in Albany. But this process, and the reason I wanted to go through it, is we're seeing more and more of these claims, and employers are a lot of times confused because it's a very different process than what you're used to if you get a court complaint, or if you get a division complaint, or an EEOC complaint. So I hope that this summary, which was intended to be a nuts and bolts procedural summary, is helpful to you. If you get one of these claims, don't hesitate to reach out to any bond attorney, especially in our Labor and Employment Department. We handle these cases regularly, and we'll be able to help you. But I hope this primer was beneficial, and thank you for being with us today.
And Adam, thank you very much. Thank you very much, Adam. I think that was really helpful. So any questions? There's my email address. And I was just going to say, where are the other email addresses? You can also contact Nick directly, as well as Adam, with anything, or any of the attorneys at Bond that you regularly talk to. Thanks for being here. Fill out the survey with topic ideas for this year. We're always looking for more topic ideas. We really appreciate that. And we'll see you again. I'll be back in a couple weeks. Gabe will be here next week. Take care. Bye-bye.